Disgraced founder of FTX, Sam Bankman-Fried, and his legal team are reportedly in talks with prosecutors to work out a deal that will allow SBF to be released on bail when he is extradited to the United States. The bail would include highly restrictive conditions, including home detention and possible electronic monitoring.
Bankman-Fried is on his way back to the United States, and he agreed to be extradited yesterday. He's facing charges of fraud related to the collapse of FTX. Meanwhile, two of his friends and coworkers have reportedly turned on him. According to reporting by NPR, Carolyn Ellison and Gary Wang pled guilty to fraud charges and are cooperating with the investigation into SBF in hopes of receiving reduced penalties. Joining us now to weigh in on this, plus what it means for the future of crypto, is professor of law at Illinois Tech, Chicago Kent Law School, Edward Lee. He's also the founder of NOU NFT. Maybe I said that right. Professor Lee, welcome to you. Great to have you with us.
Thank you for having me.
So you have been following this. Tell us, what are the latest developments with these associates of SBF reportedly working with law enforcement? Obviously, that's a standard aspect of investigations of these kinds, really of all kinds. So what's going on, and what do you expect to see?
Well, it's truly a day of reckoning for FTX. Yesterday night, the U.S. Attorney Damian Williams announced plea deals that have already been reached with Ms. Ellison and Mr. Wang, who have no doubt provided information related and implicating Sam Bankman-Fried. And those plea deals signal that the U.S. Attorney is moving full speed ahead on the case against Sam Bankman-Fried. So what I expect is that this revelation that the U.S. Attorney already has secured plea deals will put greater leverage on Sam Bankman-Fried and his, defense, and a plea deal with, his case is probably likely as well.
So Carolyn Ellison was the chief executive of Alameda Research, the hedge fund, now infamously affiliated a little too closely with FTX, and Gary Wang was the founder of FTX, the crypto exchange. What do you intuit from their plea deals and what their positions were? What do you expect that they will tell prosecutors about the alleged schemes here? What kind of information would they be privy to? And what do you think, if anything new is going to come out of those disclosures?
Well, I think the crucial piece of information that either Ms. Ellison or Mr. Wang or both of them are providing to the U.S. Attorney is information related to the knowledge of Mr. Bankman-Fried to the transactions and diversion of customer funds to Alameda Research to cover a hole that was created by a margin call back in May of this year. And if you followed Mr. Bankman-Fried's tweets and his interviews, he professed ignorance as to what Alameda Research was doing as to those funds. So I think it's quite clear that Ms. Ellison and possibly as well Mr. Wang are providing information that implicate Mr. Bankman-Fried as to his knowledge of the diversion of customer funds, which he, at least in social media, professed ignorance to.
Do you think SBF's attorneys are furious that he has given so many interviews, had so many exchanges with the New York Times, with Vox, tweets, etc., even following the blow up, the collapse, and the likelihood of there being charges?
Well, undoubtedly. I mean, I think no criminal defense attorney would recommend to their client to be speaking in any interview. And initially, Mr. Bankman-Fried had different attorneys representing him, and they, I think, resigned from the case. And eventually, Mr. Bankman-Fried retained Mark Cohen, a very experienced white-collar crime defense lawyer based in New York, But I'm sure that he and anyone else who was advising Mr. Bankman-Fried would have expressed great hesitation to any interviews or social media posts at all.
I mean, as a law professor, assuming that you have some familiarity with the elements here, I mean, as lay folks watching these interviews, it seemed like the things that he was saying were necessarily kind of incriminatory. There were incriminating. There were these moments where he seemed to reference various dates at which he professed not to know that there was a problem, and then later in the conversation, there would seem to be some confusion. In an interview at one point during the DealBook interview at the New York Times, pointed it out, said, well, you said you knew there was something going wrong on an earlier date than you had just claimed, so does that mean you had knowledge, and da-da-da-da. And it seemed to be there were these moments where even though he seemed to think that he was perhaps smart enough to best the public, that he was in fact making the kind of disclosures that would ultimately damn him in a legal context. As you watch those interviews, were you catching some of those moments? Or do you think there was some legitimacy to the idea that he might have been able to play the public without playing himself?
Well, I think you put your finger on a crucial problem once you start speaking in these interviews and on social media. At some point, you may contradict yourself and not have your story straight, so to speak. Another point I think that is worth noting in terms of the media interviews is that some of the responses of Mr. Bankman-Fried were sort of halting, as if he had to process the question and think through in a very measured or guarded reaction. And, if this were a jury and seeing somebody who has to parse through the language and just to respond to what seems like a very simple question, may make the jury feel the answer lacks credibility, right? Ideally, you want to have a client who responds without halting or without reservation, like, here is what happened, et cetera, or whatever. So I think added to the potential inconsistencies in the timeline of his knowledge, I think the demeanor and the manner in which he answered some of the questions, for instance, the DealBook interview, may not have been that convincing.
I presume, when he tries to make his defense not in the media, but in the actual, legal sense, and maybe they work out some kind of deal, so there's not really a trial, but he would say, I was in over my head, and also, crypto is by its nature very unstable. The value changes very rapidly. People who invest in it and work in the space should have that understanding that, you don't, it's like playing the lottery here. You don't really know what you're going to get. So it's not my fault that this has worked out badly for them. And I didn't do anything differently than what the space calls for. Does that sound like a kind of argument he might make? And if you disagree, what would you think he should say?
Yeah, I mean, there is some of that in his responses already where he just wasn't aware and he didn't realize what was going on. And in addition to trying to cast, I think, some of the blame on Alameda Research, that, he was not aware of what they were doing, so to speak. So there is definitely some element where he tries to profess ignorance about the diversion of customer funds. In terms of what else he may raise as a defense, there is a modest wrinkle to all of the government's cases involving jurisdiction and territoriality. And that is that this set of alleged conduct occurred across potentially many countries. And specifically, FTX had a separate company called FTX.US, which was available to US persons that did not trade in FTT, the token of FTX. And the policy of FTX.com, the main site for which the government is alleging engaged in this fraud, that site is not supposed to be available to U.S. persons. Now, the CFTC has alleged, based on information and belief, U.S. persons did get access to FTX.com, but let's assume they did not. Then there is at least a territoriality issue, whether the relevant conduct or fraud affected U.S. customers. Now, the complaints do allege, I should mention quickly, that there were U.S. investors in the company that were based in the United States. So that part of the case, I think there's no question about the jurisdictional United States nexus. But there is a kind of a lurking issue in terms of the scope of FTX.com's sort of application to U.S.-based people, which is would be a part of a criminal complaint for wire fraud or conspiracy to commit wire fraud.
Interesting. So there might be some procedural, jurisdictional outs for him, it seems. We'll have to keep following this as the case develops. Thank you so much, Professor Lee.
It was my pleasure. Thank you.
We'll have more Rising for you after this.